we still have such ambassadors currently. As for the caseload of the court, a total of 142,755 cases were pending at the end of the 2021/2022 legal year and carried over to the 2022/2023 legal year. Within the last legal year, a total of 15,025 cases were filed, while the total number of cases disposed of was 12,870. When the leftover of 2,155 cases is added to the total number of cases carried over from the previous year, being 142,755, we have a total of 144,910 cases pending at the end of the last legal year. This comprised of 42,782 civil cases, 36,061 criminal cases, 41,447 motions, and 24,618 fundamental rights enforcement applications pending at the end of the last legal year.
Unless we command the confidence of the public in respect to the only thing that we serve to the public, that is justice, then this country will cease to exist. And that underscores the importance of the responsibility that we are privileged to perform to the people of this country. And my Lord, no other profession is positioned to render this responsibility, to discharge this responsibility, but us. We are the only ones that are privileged to be schooled and instructed on the subject of law. We are the ones that understand the law. We are the only ones that understand why Nigeria is Nigeria, why we are citizens of Nigeria, why we do the things we do and the way we do them. And we are the only ones, like Sapara Williams said, to give direction to the people and advance the cause of this nation. But it is apparent that the Nigerian people, largely because of what we have done, and I say this because members of the bar appear to be so complicit in this respect, and particularly those of us who adorn the silk, we have failed in our responsibility in providing direction to the people of this country with respect to the things that the courts do, with respect to the position of the law. And so the expectation, we should have been simple if we had fed the people of this country with the right information about what the position of the law is.
My Lord should not be afraid of being dynamic. We have seen the history from Federal Revenue Courts to where we are today. We see the expansion. So the theory of dynamism must be there. The judges must be creative. If you remember, it was this court that brought the issue of taking plenary objection with the substantive matter in a rejecting process. That matter went to the Supreme Court, and Supreme Court said, yes, that's the best thing to do. Why don't you take all? And the National Assembly now said, you are aware, this is what we have said. And they coordinated it, codified it. It became part of our jurisprudence. So I enjoin you, my lords, stand to the call of the duty where activism is required, where reform is required, where decisions that will reflect public policies and justice is required. We must stand up